SJC-12583, Deborah Brown v. Federal National Mortgage Association.
Ms. Brown, good afternoon.
Good afternoon. May I reserve just 2 minutes at the conclusion?
Oh, no, we don't do that. So
Okay.
got your 10 minutes.
So may it please the court, I'm here today on this request that this court reconsider the superintendent's petition that was filed with the single justice, because we argue that the single justice made an error of law when he made the determination to deny the motion to void judgment and vacate the summary process proceeding. The reason is because of void judgment, and we relied obviously heavily on Justice Lank's decision in the Matt HSBC versus Matt case when determining that the land court judgment that issued in December of 2009 was void on its face because it exceeded the authority of the land court. Based on that void judgment, we moved forward and went to the housing court and asked the housing court judge to void the land court judgment and dismiss the summary process case, as all matters that happened after that void judgment should be deemed to be a nullity. So meeting the entire, all the litigation should be deemed a nullity from the date of that void judgment. Now, in HSBC versus Matt, this court ordered that the case be sent back to the land court and that action be dismissed based on the fact that the judgment was void on its face. So this petitioner, or I would argue that the respondents have proceeded since January of 2013 with full knowledge that there was a void land court judgment in this case.
Now, did you present that to Justice Lowy when he was single justice?
We had limited opportunity to address any of these matters to Justice Lowy because his decision came down within two business days of the housing court decision. We didn't have an opportunity to have a hearing or further brief any of these issues. And in fact, it's a bit dramatic to me that in the housing court case transcript, which appears in the record appendix for this matter on page 27 and 28, there was actually the transcript from the housing court matter when this was argued before the housing court justice. And at that hearing, my brother argued to the court that the decision had already been made, essentially, and that my case was going to be denied, and that Justice Lowy was out of town. It was just a matter until he came back that I would likely not have a hearing, and the case was going to be denied. So that was even without consideration of this motion to void the land court order.
But when you presented your written application to the single justice, was one of the grounds for the single justice's review the fact that the land court determination was void?
So the initial 211 petition was based on the fact that I had done extensive research and determined that the affidavit that had been submitted to the housing court in support of their motion for summary judgment was actually contained false and misleading statements. And I made the petition based on the research and the material that affidavit was false. Now, in retrospect, you know, the housing court judge and the single justice had the discretion to accept that petition or not. However, there was sort of the smoking gun that happened in one of the final proceedings before the housing court. We were going before the housing court to stop an execution from issuing or to stay the execution pending this court's review when an amicus was submitted to Justice Lowy from Mr. Robert Marley, which is, I'm sure, unconventional. And, you know, I happened to have read the amicus brief after it was filed, after it was on the court's docket. And immediately, when I read it, he had a reference in there to the land court judgment being void. So I created a motion and went in to the housing court hearing, which was already scheduled on the execution, and presented the motion to vacate the order. But as Justice Kafka, I believe, wrote in ISH versus MDB, that when the issue of a void judgment is limitless, is without time. You can raise the issue of a void judgment at any time. And that issue was raised within time in the housing court, and certainly was at least presented in the context of the 211 petition to Justice Lowy to enable him to take some time to review that. A void judgment clearly it changes the landscape, because a void judgment, a judge does not have discretion to not void a void judgment. Void judgment exists, and everything that follows that judgment should be a nullity. And the fact remains that the respondent was fully aware of the void judgment since the Matt decision. They were the counsel for HSBC versus, Jody Matt. So their firm was clearly aware. And in fact, this was a common practice of this firm, to get these judgments and then have foreclosure sales. So that was their practice. And when I read this court's decision in Hatcher, and you think about the prejudice against any individual to be in a summary process case, and you look at the fact that this was their pattern and practice to get the judgment and then go to have a foreclosure sale and then go into the summary process case and take possession of the property. And remarkably, the land court knew since the statute changed in 1990 that these judgments were not allowed, as Justice Link went through that history in the Jody Matt case. And the land court never changed their form of judgment until 30 days after the Matt case came out. So clearly somebody paid attention that once this court recognized that those land court orders were void, that they had to change the land court order. So this court actually finally corrected this fundamental change, that those land court orders that issued without any participation of the party whose name was in the judgment were void. And that's, in my particular case, I was not able to attend that hearing. I was not able to participate. And as the court recognizes in Matt, they do not want the person to be able to participate. That's not the point of that proceeding. That proceeding is purely to declare whether or not the person's in the military. But our land court process, unfortunately, went beyond that statutory mandate, which meant that they did act beyond their authority. So in Field versus Massachusetts General Hospital, this court ruled that, there's no discretion granted by the rule that a judgment has to be void. When a 60B4 motion is raised, it needs to be addressed at any time. And as I stated before the housing court judge, this could have come up 5 years ago, or it could come up 5 years from now. The one thing that is clear is that the respondent was knowledgeable about this void judgment from 2012, when the summary process case began. They were knowledgeable about it. They had knowledge in 2013 when the Matt case came out. And one of my arguments is, again, this stare decisis, and that there was a burden, or there was this respondent had a duty to pay attention to this court's orders in all of these cases, whether it was Marroquin, whether it was Hatcher, whether it was Jody Matt, and take the appropriate action to correct the error from the land court proceeding, or make some sort of reasonable settlement in this matter. So I thank you for your time.
Okay, thank you. Mr. Santolucido?
Good afternoon, Your Honors, and may it please the Court. Thomas Santalicito for Federal National Mortgage Association, which is better known as Fannie Mae. Fannie Mae contends that this Court should affirm the decision of the single justice because, as the single justice noted correctly and quite pointedly in his order, this case has been fully litigated over an 8.5-year period. The foreclosure that's at issue in this case took place back in May of 2010. Since that time, within a matter of days after the foreclosure, Ms. Brown filed an action in Superior Court challenging the foreclosure. That action was removed to federal court.
Yeah, there's been a long history, but the question is really, what do you say about the fact that there's an allegation that there was a void judgment in the land court?
Yeah,
because any time something is void, it could be a problem for the entire. I don't care how many cases you've gone through, how many times you've been in court.
That's correct.
A void judgment is a void judgment, right?
That's correct. But to respond to your question, Your Honor, first of all, we contend that the judgment is not void. The Matt decision had to do with standing, a mortgagee's ability to bring a service member's case, because in that case, the mortgage at issue had not yet been assigned to the plaintiff in the service member's case. In this case here, the record makes clear, I believe it's at pages 5 and 6 of the original record appendix, the mortgage here was assigned into BAC Home Loan Servicing, which was the plaintiff in the land court case. So there's no issue about jurisdiction or standing. In this case, the mortgagee, the holder of the mortgage, is the party that brought the land court action. Ms. Brown takes issue with a statement that's buried in the form judgment issued by the land court authorizing the plaintiff to foreclose. In this case, she's correct in that the service member's proceeding is a limited proceeding charged solely with determining whether the owners of the property who are being foreclosed are in the military and subject to the Service Member Civil Relief Act. And in fact, in this court's decision in Beaton v. Land Court, the court found that even if there were a defect in those proceedings, it does not affect the validity of the foreclosure itself. So my argument to Your Honor's point is, one, the judgment isn't void. It was brought by the correct plaintiff. There was an assignment of the mortgage into BAC Home Loans prior to that proceeding. Two, that even if there was some sort of technical defect in the land court's judgment, it doesn't void the foreclosure itself, and Beaton is the case that stands for that. So, as I said, the issue was, the case does have a long history. It was fully litigated. Ms. Brown's housing court decision, the summary process case in housing court, the housing court had entered judgment in my client's favor. That case was reviewed and affirmed by the appeals court, and this court denied further appellate review. So the case has been litigated fully. These issues could and should have been raised earlier, but as to Your Honor's point, we contend that the judgment is not void, and even if it was, even if there were some sort of defect in the service member case, it has no bearing on the foreclosure itself unless one of the parties is actually in the military, which is not being alleged here. Turning briefly to a couple of other issues that were raised late in the process, as Chief Justice Gantz sort of alluded to, this land court issue was not mentioned in Ms. Brown's original petition or her motion for reconsideration to the single justice. These issues first surfaced in a motion to vacate and void judgments, which had been directed to the housing court, not to the single justice. Despite that, Ms. Brown did docket the motion with the county court, and Justice Lowy did review and deny the motion. Ms. Brown also takes issue with a post-remand order of the housing court amending the execution, and Ms. Brown didn't seek review of that order by a single justice of the appeals court. So she had the opportunity to review that issue previously and failed to do so. So in sum, we believe that the single justice was correct in finding that this case was litigated extensively over an 8.5-year period. I'll add parenthetically, to great expense to my client, and that the foreclosure has been litigated, the right to possession has been litigated. She's had a fair and full opportunity to litigate these issues in both the federal and the Massachusetts courts over an extensive period of time. And she's either done so and made use of her appellate recourse, or in the case of these other few issues, failed to do so. Because of that, we believe that the single justice committed no error of law or abuse of discretion, and that this court should affirm his decision. Unless the court has any other questions, I'm happy to rest here on my brief.
All right, thank you.
Thank you.
Court all rise. Hear ye, hear ye, hear ye.